Okay, here comes to our last speaker today, Mr. Sean GIBBS. Mr. Sean GIBBS is the CEO of Hanscom Intercontinental Limited. He has held directorships and senior commercial positions with contracting and consultancy firms in the United Kingdom and internationally. With over 30 years experience in the onshore and offshore construction and engineering industries across the globe, Sean has worked across the continents of Europe, Asia, Middle East, Africa, and the Americas. He has acted as quantum expert before various dispute resolution tribunals, including adjudication, dispute board, expert determination, and arbitration. The topic that Sean will share with us today is dispute avoidance and dispute resolution. Mr. GIBBS, please.
Great, okay.
You're right.
So my name's Sean GIBBS, and I'm going to be talking about dispute avoidance and dispute resolution. As was mentioned, I work for the company Hanscom Intercontinental, and we provide expert witness and expert advisory services. We cover construction, engineering, and shipbuilding. I myself have been called to the bar by the Middle Temple. I'm also a fellow of the RICS. I'm not going to talk too much about that. The company itself has got multidisciplinary experts, and we work in a wide range of ADR forums. In terms of dispute resolutions, it's recognised as a problem globally. So if you look at the Crux report done by HKA, there's disputes and issues arising from disputes across the globe. In particular, in the recent Crux report in 2022, they looked at 104 projects in Asia across 22 countries, and their average values claimed on those projects was $90.4 million. That's US dollars per project, and 65% average EOTs were claimed on each of those projects. So disputes are a problem, and they're a particular problem in the construction industry. In the United Kingdom, despite having many standard forms with dispute resolution and tiered dispute resolution, in the last couple of years we've actually had a cross-border agreement to try to implement a conflict avoidance pledge. This recognises that before a matter becomes a dispute, it can be avoided by taking robust action. Some of the people that have signed up will be obviously known to people in Hong Kong, such as the Institute of Civil Engineers, the ICC, that's the International Chamber of Commerce, Dispute Resolution Board Foundation, as well as the Chartered Institute of Arbitrators. And it's quite unusual in terms of the conflict avoidance process that not only did large professional institutes want to sign up to this, but also some of the companies doing some of the largest projects in the UK. So Transport for London and Network Rail, probably two of the largest employers of construction clients. Now, the conflict avoidance pledge itself is supported by other tools and information. So what they've done is they've published a 16-page guide, and in this guide it gives you justification for early conflict avoidance and early intervention techniques. Conflict avoidance and dispute resolution processes are outlined in the guide, and they believe that it can be dealt with by dealing with contract provisions. They recommend conflict avoidance panels. These conflict avoidance panels operate in a number of ways, including early neutral evaluation and project-based dispute boards, as well as evaluative mediation. What they've also done as well is create a toolkit, a conflict avoidance toolkit, which helps people try to avoid conflicts by pre-contract preparation, the utilisation of dispute avoidance, recognising early intervention is key, recognising that amicable resolution is more preferable than having to go on to dispute resolution. Now, you probably wondered why I outlined that. Obviously, in the United Kingdom, for many years, we've had both the NEC 3 and NEC 4 contracts, as well as FIDIC contracts. And that's what I'm going to be talking about today for the majority of the time, of the dispute resolution and dispute avoidance processes in those two contracts. Even though we've had these contracts, the conflict avoidance pledge was deemed necessary by people in industry. So it just goes to show that some of the standard forms aren't necessarily keeping up with best practice in terms of dispute avoidance and how to resolve the disputes once they arise. In terms of the NEC contract itself, the latest version of NEC is the NEC 4, and they have various dispute resolution processes in there. They're called W1, W2, and W3. W1 and W3 deal with a situation where the United Kingdom Housing and Generation Act doesn't apply. And so for the purposes of today, I'm going to be looking at just options W1 and W3. These are actually applicable and can be utilised either in Hong Kong or in the Greater Bay region in terms of dealing with disputes. So the NEC 4 contract also has a subcontract, and it's the Dispute Resolution Services contract. And it doesn't matter if person's acting as an adjudicator or a dispute board member, they'll enter into this Dispute Resolution Services contract in conjunction with the parties. Option W1 is essentially a multi-tier dispute resolution option. What it requires is that the parties refer all of their disputes to the party's senior representatives, and these will be specified in the contract data. And this is a mandatory step before you can escalate it further, i.e. you can't go on to arbitrate or litigate unless you followed this process of going first to the senior representatives that are specified in the contract data. It's been said that it's become long-winded and open to abuse, but having to follow the senior representative process, but it has had some success. Essentially, there's a process which is dictated, and that is that each party must submit a statement of case within a week of notification. The submissions are limited to 10 sides of A4 paper, and also supporting evidence. Senior representatives, though, can attend as many meetings and use any procedure necessary to resolve the dispute over a period of no more than 3 weeks. So the early intervention by senior representatives from both sides is viewed as working successfully, or could lead to working successfully in terms of avoidance of disputes and also maintaining the parties' relationships. So, for example, where you've got a large client who does a lot of repeat work, they're probably not going to want to fall out with their contractors, and similarly the contractors aren't going to fall out with a good employer. At the end of the dispute resolution process, a list of issues is produced, and the project manager and contractor must put any agreed issues into action. So the process itself, though, is to be without prejudice, and no evidence, either statement of case or the discussions, can be disclosed in subsequent proceedings. So some of the rationale for this is that it's going to allow the people to be more open and transparent on what they're doing and saying. Adjudication is also a secondary process under W1, and arbitration and litigation are the final resolution processes under that particular form. If you do go to adjudication and you're not happy with a decision, then there's the option then to proceed further on to refer the dispute to a tribunal for final determination. Under the NEC form of contract, essentially the parties either choose litigation or arbitration as the tribunal, and it gives some flexibility in that. The option W3 is quite different to W1, and it's used outside of the United Kingdom, or where the Construction Act doesn't apply in the United Kingdom, and it uses a DAB, a Dispute Avoidance Board, rather than adjudication. The Dispute Avoidance Board in the NEC is very different from the Dispute Adjudication Board in FIDIC, and I'm going to touch upon that later on when I talk about the FIDIC forms of contract and how they can be used to avoid or resolve disputes. And what is important is that the DAB procedure must be followed before either party could refer the dispute to court or arbitration. The way that the DAB has been designed in this suite of contracts is that it consists of 1 or 3 members. The number of members is stated quite clearly in the contract data in Part 1. If there were to be 3 members, both the client and contractor nominate an individual, and they're named in the contract data, and the parties jointly choose the third member, there is also provisions for dealing with a member not being able to act. So that means that the board won't fail because they're not properly constituted or someone leaves. As I touched upon before, the dispute board members will be appointed under the NEC DRSC form of contract. That's the green contract that you saw on my earlier slides, and that applies to all of the W option clauses that I've touched upon. The DABs are supposed to visit the site at intervals. This frequency is specified in the contract data, and the aim is that the DAB will inspect the progress of the works and become aware of potential issues, thereby resolving disputes before they become disputes. A potential dispute is notified to the DAB between 2 to 4 weeks after notification to the other party and the project manager. The dispute board itself only makes recommendations. It doesn't issue a binding decision. If you're in America, they may term this a dispute review board, and it's akin to a dispute review board. Unless the parties have resolved the issue by the end of the visit, the DABs will provide a recommendation for resolving issues. Only if a party is dissatisfied with the recommendation is a dispute referred to either court or arbitration as appropriate. The dissatisfied party must notify the other party the matter which it disputes and state that it intends to refer to court or arbitration as appropriate within 4 weeks of notification of the DAB recommendation. I'm now going to look at the FIDIC forms of contract. Now, the FIDIC forms of contract have been around since 1957, and it's only in the sort of latter years of their publication where you've started seeing the active use of dispute boards and dispute boards with a remit to help avoid disputes. The FIDIC forms of contract are now published in Mandarin. I'm not sure exactly which versions are currently available in Mandarin, but there are official forms of the contract. The 99 forms have a creature known as a dispute adjudication board. The dispute adjudication board is very similar to a dispute avoidance and adjudication board, which was created by the 2017 forms. And the reason I say that is under both contracts, the dispute board visits site regularly, has input. It can help resolve disputes before they arise by informal negotiation. They can also provide opinion to the parties. They can provide non-binding recommendations, and they can also, unlike the NEC form, they can provide a binding decision. Now, the 2017 forms of contracts issued by FIDIC were slightly improved, and the emphasis was more on being able to avoid disputes, and that's why the particular form of dispute there is entitled the Dispute Avoidance and Adjudication Board. In terms of comparing and contrasting NEC and FIDIC, the NEC 4 W3 process has a dispute avoidance board. They provide a recommendation. If the parties don't accept the recommendation, then it can be resolved by the tribunal. The FIDIC forms of contract, the dispute adjudication and avoidance board, can firstly offer informal discussions. They can also provide opinions. Then if there isn't a parties reach agreement, they're able to issue a binding decision on the matter. And then the final recourse there is to ICC arbitration. If you look at the FIDIC forms, for many years they've always chosen ICC arbitration as no litigation. One of the reasons specifically for this is that the contract is used in an international setting. It quite often involves parties from different jurisdictions contracting. Hence, they've always chosen to include the ICC arbitration provisions there, as it's deemed most suitable for that cross-border type of work. This is in contrast to the NEC. The NEC contract itself originally was created for the use in the United Kingdom. It's obviously been adopted and used around the world, not to the extent that the FIDIC forms of contract have. But if you look at the Hong Kong market, they've been regular users of the NEC suites of contract now for many years. And then obviously their process in the NEC is to choose between a court or arbitration. Probably one of the disadvantages of the NEC is it's not explicit in its arbitration processes, whereas the FIDIC forms of contract are very explicit in the way that the ICC arbitration will be conducted, and outline the processes and procedures to get the arbitration underway, and also to maintain it. One thing that you may find, though, it doesn't matter which forms used, is that some courts may not recognise an interim and binding decision when it comes to enforcement, and this is particularly found in civil code countries. In terms of other forms of contract, obviously there's EPC forms of contract which people use. These are particularly for oil and gas, petrochem, chemical engineering. They don't necessarily have all of the necessary tools and mechanisms to enable them to operate. So, for example, the NEC4 itself has a very detailed dispute resolution services contract, which supports the main contract provisions, and it also allows for the parties to easily engage those that would act as adjudicator or dispute board member, or even arbitral tribunal member. So that's a whistle-stop tour of the two sort of main forms of contract that you might come across. As I touched upon at the beginning, even though in the United Kingdom that we had standard forms and we had standard form provisions, professional bodies, clients, as well as contractors felt necessary to launch a conflict avoidance process and a conflict avoidance pledge. This is because they felt that the standard forms were lacking in some ways. So in most of the standard forms, disputes almost arise, then are resolved. And under this conflict avoidance process, the plan is that you don't allow the problems to arise. So you try to head them off. It encourages a lot more communication and dialogue than may be emphasised in the standard form contracts. That's not to say you can't amend the standard form contracts, but it's something to bear in mind. Early neutral evaluation is akin to some of the processes that I've touched upon in the NEC4 and the FIDIC forms of contracts. Project-based dispute boards are obviously available under both the NEC and the FIDIC forms of contract. What's not explicitly spelled out in either of those is the use of evaluative mediation, and that might be something that you may wish to amend in those standard form contracts to include a sort of more formalised mediation process. It's certainly something that's on an international basis is becoming more and more used in construction projects. I've already touched upon the conflict avoidance toolkit. If you go to the website, which is managed by the RICS, and you look for conflict avoidance pledge, you'll be able to find the toolkit. I certainly encourage you to look at it. There's some very useful things to think about in there, particularly at pre-contract stages. And probably the most important thing to do when negotiating a contract is actually think about the ways that you're going to avoid disputes. If we go back to the first slide, I looked at where you had the spread of disputes around the globe. It's a global problem, disputes and dispute resolution. It's tackled in different ways in different countries. So if you look at the North America, one of the tools that they've decided to use over there on their large infrastructure projects are dispute review boards. probably the biggest drawback with a dispute review board is that you can go through the process and then you don't have a binding decision. So that's something that diminishes its importance. If we look at South America as a whole, sorry about that, the slides just jumped. South America as a whole didn't use dispute boards for many years. In the sort of last 5 years, you're starting to see an uptake in dispute boards. And the forms of dispute boards there are dispute adjudication boards. That means that they can issue binding decisions. If we look at Africa as a whole, they have a lot of investment in the country. Quite a lot of it is from multilateral bank funding. They tend to use FIDIC forms of contract for a lot of the works, and they'll also include the dispute board provisions contained within the FIDIC forms of contract. If you look at Europe, which is obviously in green on the map, the United Kingdom and Ireland are probably the anomaly because we have a statutory construction adjudication process. That's really meant that dispute boards haven't really been utilised in the United Kingdom to any great extent. If we touch on then the mainland Europe, we were starting to see more and more use of dispute boards in part of the provision. Some of this is because of the use of FIDIC forms of contract, but it's also because the advisors and lawyers that are advising parties are aware of the benefits of dispute boards. One sort of region that doesn't really use dispute boards, or historically hasn't used dispute boards, is the Middle East. They'll quite often have a tiered dispute resolution clause, which will eventually lead to an arbitration of some sort. If we go down to Australia and Australasia, historically they didn't use dispute boards, though they are now. So the dispute board mechanisms seem quite popular. Turning to Asia, Hong Kong for many years has had various standard form contracts. In terms of public works now, the NEC certainly seems in the predominance. China itself has its own standard forms of contract, as well as starting to use FIDIC forms of contract. If we turn to some of the other Asian countries, such as India, historically they didn't use FIDIC forms of contract. They had various bespoke forms of contract that they were using, and standard form contracts which were unique to India. With a large investment in infrastructure, they're starting to use the FIDIC forms of contract. In terms of the former CIS states, so you have places like Azerbaijan, Kazakhstan, they tend to use EPC, EPCM contracts, so they're oil and gas projects. And then in some of the other sort of projects, some of their larger building or infrastructure projects, and they tended to use FIDIC forms of contract. So I'm just going to jump back through the slides. So in terms of what Hong Kong and the Greater Bay Area can do, is they can learn from what everyone else is doing around the world. They've got a real choice at the moment where they can decide to adopt FIDIC forms of contract, or based on the knowledge and expertise of those who work with contract forms in Hong Kong, they can decide to choose to go with the NEC forms of contract. No matter which form of contract you choose, you do need to spend money training people and able to administer the contracts properly. One of the biggest sources of disputes, according to studies, is the failure for people to administer contracts. So it doesn't matter which form of contract you choose, but you must have people capable of administering it correctly if you do wish to avoid disputes. Okay, so that's the end of the formal part of my presentation. Yeah, I can see the question. So the question is, in terms of dispute avoidance, which contract form is more effective from your personal experience, NEC or FIDIC? I've got to be honest, both of them are just as effective as the other, and it really depends on the parties and the players that are involved in administering the contracts. So, for example, I've used FIDIC in Africa, and it didn't help avoid disputes on a particular project, but that was more to do with the people that were involved in that particular project. Similarly, I've used NEC in Africa and South Africa. It didn't help avoid disputes, but that was primarily because of the parties and the way that they were staffing the contract, and they didn't comply with the contract provisions. Their behaviour and conduct led to a lot of the disputes, and quite often the disputes were unnecessary. Equally, I've used the NEC forms of contract in the United Kingdom, and they've worked extremely effectively in avoiding disputes. What I do see, though, and this must be borne in mind, is that parties who believe they're going to have a long-term working relationship after that particular project will make more effort to avoid disputes, and they'll be more willing, one, to spend the time properly administering the contract, and two, being reasonable in how they conduct themselves. And I think that's an important key. It's not just the forms of contract, it's also the party's desire for a relationship afterwards. The NEC form of contract's been criticised by many because it is quite onerous in terms of administration staff, which you need to do to comply, because it's got quite strict time barring provisions, and also the way that you notify time and cost via the compensation event. But I think both forms can work very well. What I would say is the NEC forms of contract have quite a bit of literature about them, but not to the extent that the FIDIC forms of contract have. So if you do have inexperienced staff and they need access to resources, I'd say that the FIDIC forms have a much more greater wealth of resources available to them to help parties understand various issues that arise in each clause, and also how to resolve them or how they can interpret them.
Sean, question 2. FIDIC is not very common in Hong Kong. Would you suggest to introduce FIDIC for those mega-scale infrastructure projects here?
I'd certainly encourage people in Hong Kong to look at the FIDIC forms of contract. Over the years, they've grown. So you've got everything from the FIDIC Red Book, which can be used for works which are designed by the employer, through now to the Emerald Book. The Emerald Book's designed for underground works. So, for example, MTR, tunnelling works. I know there's a lot of large complex tunnelling done for drainage in Hong Kong, and the FIDIC Emerald Book would probably lend itself well for that. Just as with any sort of new form of contract introduced into a market, there'll be a learning curve for people. I'd suggest that the FIDIC form it's probably got one of the lower learning curves. I believe it's quite intuitive, and anyone who can read a contract will be able to read the FIDIC form and apply it easily. Also, what you've seen in the years is you're getting more people working on a cross-border basis. And when I say that, for years there were only a few limited number of large contractors in Hong Kong, and they were doing work for Hong Kong clients. What you're seeing is now that you've got, say, Chinese developers, and you may have Korean contractors coming into the marketplace. A lot of these companies that work on an international basis do like the FIDIC forms. They understand them. They're happy with them. That's not to say that you should throw out the NEC. I think this NEC still has its place in Hong Kong, and obviously it's quite well established now, and there's a lot of people experienced in utilising it. So I've got a question 3. And the question 3 is, how do you comment on the effectiveness of the various adjudication laws in different jurisdictions for the promotion of speedy resolution of payment disputes, often between subcontractor and main contractor? E.g., Singapore makes it very speedy to decide within 3 to 4 weeks. Hong Kong is going to legislate a similar one in the next year, ? Okay, in terms of adjudication, it differs around the world. So if you look at the statutory schemes, so for example, if you take the United Kingdom, I think the United Kingdom is the most wide-ranging adjudication scheme out there, and that's because you can refer any dispute at any time. It's not limited to payment disputes. Once the adjudicator has been issued the referral, they have 28 days to make a decision. Those 28 days can be extended unilaterally by 14 days by the referring party, which means that it could go up to 42 days. And then also the parties, if they both agree, they can extend the adjudicator's decision period even longer. I've seen a wide range of disputes determined within 28 days, so it is quite possible and it's quite speedy. if we then say move to somewhere else, so for example, if we take South Africa doesn't have a statutory adjudication process. It does, though, have contractual adjudication. So they use the FIDIC forms of contract and dispute boards in South Africa. They also have their own forms of contracts, such as the JBCC and a wide range of others. They use the NEC as well there. They don't have statutory adjudication, but adjudication there follows the contractual process that's stated. One thing that they do have, there's extremely supportive courts, and the courts in South Africa were strongly influenced because of the common law precedent. That means they took the decisions from the United Kingdom courts, and they're quite quick to enforce. And they're normally enforced no matter what. Even if there's a breach of natural justice, the courts in South Africa will tend to enforce, and they enforce on the basis that's what the parties signed up to. And even though it's only interim and binding, that they will give an enforcement. In Hong Kong at the moment, and this is going to be key to understanding if adjudication is going to work successfully or not, is obviously you've got the statutory payment provisions mandated by the government now. I haven't had much feedback from that yet, but I certainly think there's going to be a lot of lessons learned in this initial process. In the United Kingdom, we've had statutory adjudication now for over 20 years. King's College have just recently produced a report on adjudication. If any of you can go on the King's College website and look for their adjudication report, I certainly recommend it. It's one of the most detailed reports ever done on adjudication in the United Kingdom, as well as people's perceptions. You can see how the different UK adjudicator nominating bodies are working on what they're able to do, on what they're not able to do. You'll also see suggestions for changing the construction acting scheme. Probably the biggest issue we have in the United Kingdom is that they've got exemptions. So, for example, the oil and gas industries are exempt, and there's now a lot of pressure for these exemptions to be removed. Singapore and Malaysia, I believe, have got quite similar schemes in as much as the adjudication deals with payment disputes, and it's just relatively quick. My understanding is as well that the enforcement in both Malaysia and Singapore is extremely quick. If you go across to Australia, Australia is obviously a federal state. Each state's got its own sort of way of doing things, and for years they haven't been able to align. And I think that one of the issues in Hong Kong is obviously dispute boards and adjudication were first utilised on the Hong Kong airport going back to the early 90s. And since then, the reason that adjudication has been hard to implement in Hong Kong is you had a lot of different professional bodies who were unable to reach agreement, and this obviously gave room to the government to say, well, if you can't agree between yourselves, what can we do? We don't know, who to listen to, what we should implement, what we shouldn't. So the latest government initiative in Hong Kong, I think, should be warmly welcomed. It should be analysed, and it's certainly going to guide the creation of the bill that's going to go before the local legislature. Has anyone else got any other questions at this point?
Well, due to time constraint, I believe that would be your last questions. Ladies and gentlemen, would you join me in another round of applause for our speakers?